Thank you very much, Mr. Speaker, and I will be sharing my time today with the member from Saskatoon, Rosetown, Biggar. Mr. Speaker, I want to take a few minutes as I begin to speak on Bill S-2, the bill that would give real matrimonial property rights to Aboriginal women and men living on reserve, and talk a little bit about why this bill is so important to me personally. And I have been, I think, very emotional whenever I stand up and speak about this. I feel very passionate about it. Mr. Speaker, I want to tell you why. My granddaughter, Arcadia Faith, is a baby girl just over a year old, and she's of Aboriginal descent. My son's girlfriend, a beautiful young Aboriginal woman named Tamara, is a status Indian. And when I look at my granddaughter, Arcadia, and I look at her beautiful mother, Tamara, who together with my son are trying to build their lives, and I realize that my granddaughter and her mother do not have the same rights as I do as a Canadian woman, just because they are born as status Indian women. It saddens me and troubles me and literally breaks my heart. It breaks my heart not just for these two Aboriginal women who are part of my family, but more importantly for the tens of thousands of Aboriginal women and frankly men who are victimized over and over and over again because of who they are and because of their Canadian status. So, Mr. Speaker, when I speak about this issue and when I hear the opposition say, it's not Aboriginal women talking about Aboriginal rights, Mr. Speaker, as Canadians, we don't accept that argument anymore. We are here standing up for those who nobody else will stand up for. And on this side of the House, Mr. Speaker, and I, as a grandmother and as a mother, am standing up for my Aboriginal granddaughter and for her mother. And I'm very proud to do so, and I will do it for as long as I can and until we see the same rights that are afforded to every other Canadian afforded to Aboriginal people. Mr. Speaker, I want to say as well that it does trouble me. I have a lot of respect for many of the opposition members who I believe are here for the very solid and very good reasons. But, Mr. Speaker, it does sadden me deeply when they oppose this legislation. And frankly, and I think if they look at themselves in the mirror, they know they don't have any good reason to oppose it. Thirdly, I will say I'm very disappointed there has not been more coverage of this issue in the media. I do panels almost on a weekly basis. I do news panels on the RCMP. I do news panels on prisoners and all kinds of very interesting topics. Why we are not doing panels and why we're not talking about Bill S-2 and the rights of Aboriginal women, we should be talking about this day and night for the next several weeks. We should have been talking about this. Mr. Speaker, I'm troubled. And I think it begs the question, and maybe we all have to look in the mirror, as why is it that Aboriginal women in this country deserve to be virtually ignored by not only the media, but sadly by the opposition, who again, I believe are here for the right reasons, but I would challenge them to stand up and to have the courage to maybe vote against their leader, maybe vote against their party, but do the right thing and support Aboriginal women and the rights of Aboriginal women on reserve. I do want to take a few moments, Mr. Speaker, and talk about what our government has done in terms of consultation. I think it's important that we look at the statistics as far as what Aboriginal women face. Approximately 15% of Aboriginal women in 2009 in a marriage or in a common law partner reported that they had experienced spousal violence in the previous 5 years. So this is a very serious and a relevant issue. Of those who have been victimized, 58% reported that they had sustained an injury, compared to 41% of non-Aboriginal women. Further, 48% reported that they'd been sexually assaulted, beaten, choked, or threatened with a weapon, and 52% of Aboriginal women reported that they felt threatened and feared for their lives. Bill S-2 is designed to address this very real need in First Nations communities for fair matrimonial rights and interests. It proposes not only to protect today's victims, but also to prevent similar injustices from occurring in the future. Bill S-2 and its implementation plan have been meticulously developed to take into account the realities of life on First Nations reserves. For example, due to the remoteness of many First Nations communities, the regulations under this legislation would enable an individual to secure an emergency protection order by telephone, email, or fax. Now, right now, Mr. Speaker, they could be crying for help. They could be phoning. There is no protection order for them. So not only will this bill bring in the ability for a protection order, but it can actually be acquired by telephone, email, or fax for this emergency protection. Bill S-2 would also authorize a peace officer or other appropriate person to apply on behalf of a spouse or common law partner. Again, providing that support that's so much needed in times of crisis. In addition, the government plans to support the implementation of this legislation through education and training. Frontline police officers will be given tools, policies, and training to effectively enforce relevant laws governing matrimonial property rights. Education material and opportunities are also planned for provincial and territorial Superior Court judges. This will provide judges with a clear understanding of relevant on-reserve social issues, along with Bill S-2 and First Nation laws. Mr. Speaker, there is a two-part phased-in approach proposed for the implementation of Bill S-2. The first part would allow courts to apply First Nations law. This is very important and something that we recognize. The second part is a provisional federal regime that would apply in those communities that have yet to develop laws related to matrimonial rights and interests. The federal regime would not take effect until 12 months after Bill S-2 becomes law. The end result, however, would be that laws that protect the matrimonial rights and interests of all Canadians, Aboriginal or non-Aboriginal, regardless of where they live, would occur. Some First Nations currently deal with family violence issues by bringing an independent third party into the household to help resolve disputes, and their laws would continue this process. First Nations would be free to create laws that align with their traditions and cultures. Laws developed under the mechanism proposed in Bill S-2 must satisfy only a few criteria. They must be endorsed by a majority of members in a free and open referendum, and they must respect the Canadian Charter of Rights and Freedoms and the Canadian Human Rights Act. And I don't think anybody can argue that Aboriginal people should not have the same rights that we enjoy under the Canadian Charter of Rights and Freedoms or under the Canadian Human Rights Act. To suggest the opposite, Mr. Speaker, some would say is not only unfair, but is extremely discriminatory. To support this empowering and culturally sensitive approach, our government will fund the creation of a Centre of Excellence for Matrimonial Real Property. With this Centre of Excellence, First Nations communities will have support and resources as they draft their own regimes. During its life cycle, the Centre of Excellence will become an important resource to synthesize important tools, communications, and research activities, and assist First Nations communities and organizations in the development and application of the new legislation. In addition to its critical role as a central resource, the Centre of Excellence will be supported by an advisory committee comprised of key stakeholders, such as the Government of Canada, Aboriginal organizations, non-governmental organizations, and Centre of Excellence staff. This committee will provide non-binding guidance on the direction of the Centre in such areas as research and implementation-related activities. Mr. Speaker, by endorsing Bill S-2, we can close this deplorable legislative gap and start the real and necessary work required to prevent the gap from claiming new victims, while putting an end to the pain and suffering that countless children and women are currently experiencing. It's a time, Mr. Speaker, that all Canadians, regardless of where they happen to live, have access to a process to help them receive protection from domestic violence and abuse. Clearly, this bill would provide First Nations women with rights and protections in situations of domestic abuse, and it is an essential part of any effective solution of violence against women and children. And we talk about that so much in this House, whether it's, again, murdered and missing Aboriginal women, whether it's violence against women and young girls in other parts of Canada. This is a very direct thing that we can do to help women on reserve. And you know, Mr. Speaker, I hear words like we need to consult and culturally appropriate and treaty rights, and all of those things are extremely important. But if you are a young Aboriginal woman and somebody looks you in the eye and says you don't have the same rights as every other Canadian because of who you are, because of your ethnicity, because you were born a status Indian, and in Canada we are not going to protect that. Mr. Speaker, that's what the opposition is saying. I beg them, Mr. Speaker, I ask them to reconsider, to pass this. Mr. Speaker, we're going to do everything we can to pass this. I think we have the votes to do it, but more importantly, what a wonderful, strong message it would send to Aboriginal women if the opposition stood together with us, and as one Parliament of Canada, we supported and said, Aboriginal women, we are here for you. We will not turn our backs on you, no matter what opposition we have. Mr. Speaker, I ask the opposition to do that.
Before I go to questions and comments, just want to remind all honourable members that if they want to ask a question, they ought to wait until the speech is over as opposed to standing several minutes in advance in order to hopefully catch the eye of the speaker. Having said that, questions and comments, the honourable member for Algoma, Manitoulin, Kapuskasing.
Thank you, Mr. Speaker. And again, she said how consultation is important, but there's other avenues. Well, I can tell you that according to the law and the inherent rights of First Nations, it is a mandate for this government to consult. So again, let me remind her about Chief Shining Turtle from Whitefish River First Nation. He goes on to say, while MRP laws may be needed for a handful of First Nation communities, what is desperately needed is a capacity building and funding to support First Nations to work with their communities to come up with their own laws and local dispute resolution mechanism. We already know how residential schools, we already know from residential schools how things turn out when Canada imposes its own views on Aboriginal peoples. So again, Mr. Speaker, here is a community that has had Matrimonial Real Property Act already in place, or legislation already in place within their own community. Why is it that this government doesn't just provide capacity and resources to other First Nations who are in need? Because there are a lot of First Nations that already have that. Thank you.
The Honourable Parliamentary Secretary.
Well, Mr. Speaker, this is what I continually hear from the opposition on this matter. A bunch of mumble-jumble, Mr. Speaker. Instead of talking about the honourable colleague was talking about, if she is a woman, would like to have the same rights as I have as a non-Aboriginal woman. Let's talk about basic human rights. As a woman or a man in Canada, I am free from violence. I am free to acquire assets, and if I go through a divorce, I actually can have half of those assets. The law makes sure that happens. Why won't that member stand up and, instead of just talking a bunch of talking points and bureaucratic mumble-jumble, actually stand up for women in this country who live on reserves and happen to be born into as a status Indian? They should have the same rights as I have as a non-status Indian.
Right. Questions and comments. The honourable member for Westmount Ville-Marie.
Mr. Speaker, it is one thing to debate a bill, and we're here to debate a bill on its own merits, but the sanctimony and hypocrisy coming from that side of the House is mind-boggling. Right. The member said, let's look at ourselves in the mirror. Well, let me remind her, this bill started off as C-47. What happened to it? It died on the order paper because the Prime Minister called a sudden election in 2008. It came back as C-8. It died again on the order paper. Why? Because this government prorogued in December of 2009. It came back again. This time as S-4. It had 7 months. They didn't do a thing with it. It came back as S-2 in May of 2011. It's been there almost 2 years. What did they do? But now we're in a big rush. What does this government have to say about the priority of this bill?
The Honourable Parliamentary Secretary.
Mr. Speaker, what that honourable colleague clearly didn't hear is this actually is very personal to me. My granddaughter is a member of the First Nations. Her mum is a status Indian. And Mr. Speaker, I only speak for 2 Indian women in this country, but Mr. Speaker, there are tens of thousands of Indian women that deserve the same rights as we do sitting here, non-Aboriginal women. So, Mr. Speaker, that member can holler and yell. Mr. Speaker, he can do the same thing that the opposition, the NDP, are doing. This is a basic right for every single Canadian. Aboriginal, non-Aboriginal women should have the same rights. That's what this is about. And Mr. Speaker, here's the good thing, that I can say to my granddaughter, we got it passed, we got it done, we are making sure that Aboriginal women have the same rights as everybody else.